and you told him not to drive, it was because the state told you that he had an ALR suspension. But I've got for you, Judge, I couldn't access it at the time because I don't have access to our closed files. This is an ALR dismissal order.
Oh, okay.
There was never a suspension on his license at all. He's been good to drive.
But he was also drinking.
Well,
But the concern was that he was drinking. And
But Judge, you told him before you left that that you were doing this because there was already a suspension on his license that he couldn't drive. I never got the impression that you were taking that action because he was drinking.
In the opening moments, Judge Grayhouse calls the defendant forward, and immediately things get tense. The attorney steps in quickly, trying to explain that this entire situation began because the court was originally told the defendant had a license suspension. But now he says that wasn't true at all. This sets the stage for confusion, frustration, and a whole lot of courtroom drama. Do you think this confusion started because of bad communication or someone trying to be clever?
he was drinking allegedly, and the
Yes.
license was suspended.
Yes.
Can you run his license, please, state?
Your Honor, this should be eligible to.
Did it just become eligible, or when was it eligible? You know what, let's do this. I have a line of people, I've got arraignments. Let me put this off a little bit because this is going to take a
I
lot
have
more
to go to the
time.
doctor's office. I sent you an email on Friday when you said this. I'm supposed to be at the doctor. I took today off, but I never got a response then when I asked to move this to tomorrow. So I've got to get it done. I've got to be at the doctor.
So we can do it tomorrow. You want to do it tomorrow?
I'm already
Let me
here,
look at
Judge.
what.
The judge clarifies the real issue. The concern wasn't just the alleged suspension. It was that the defendant had been drinking and driving. Meanwhile, the defense insists the judge only restricted driving because of the supposed suspension. Already, the judge and defense are seeing the same event from totally different angles. The tension is growing fast.
I'm already here.
Your Honor, it looks like it was lifted on 4/2/2025.
So what day was it lifted?
4/2/2025, from what I can see on this license. It's the license.
And what are the days that he's alleged to be driving?
The second judge, let me double check.
And does he have an interlock as well?
Yes, Judge, he has interlock. He was alleged to be driving on the second and the third.
Furthermore, Judge, the bond conditions that you sign.
Next, the judge asks the state to run the defendant's license. While waiting, the defense pushes again. My client thought he was allowed to drive. Pretrial services said he could. But the judge doesn't accept that. He makes it absolutely clear. A court order is a court order. I don't care who told him otherwise. A powerful moment that shows how strict and unforgiving courtroom rules can be. Whose side are you leaning towards so far? The judge or the defense?
Number 28, nothing on those bond conditions says he can't drive. And my client tells me that when he went to pretrial services, he was told repeatedly, because he asked repeatedly, if he could drive. And so I think pretrial has the apparent authority to tell him what the bond conditions are, especially for somebody, a layperson who, when he goes there, he doesn't.
There is a no driving affidavit on file as of March 28th, where I ordered him not to drive. Just because you think you can drive doesn't give you the right to just go start driving in violation of a court order. You come here, you ask for permission, and then we give you permission. You don't just go do something and ask for forgiveness after the fact.
He was told by pretrial services.
I don't give a damn who.
The defense fires back with even more details, insisting the information was wrong from the start and that the client never had an ALR suspension at all. Documents, emails, dismissal orders. The whole case suddenly turns into a battle over paperwork accuracy. But for the judge, none of that matters if his order was ignored. This moment highlights a huge courtroom conflict: misinformation versus responsibility.
Jesus tells him.
Judge, you don't.
Doesn't matter. A court order is a damn court order. Just because pretrial services tells you something doesn't. Really? Is that what it's now come to?
This was all premised on wrong information that he couldn't drive. He can drive. There's nothing wrong with this license. There was no ALR suspension ever. The state told you that. That's why you.
Was a suspension
It was
and
not
it
an
was
ALR suspension,
lifted
Judge.
on,
There was no ALR suspension. I got the case dismissed. It's not possible. I mean, would you like to see the email or the dismissal order, Mr. Jurisich? Because it's right here.
Dude, I'm just looking at the records.
That's fine. I'm showing you.
ALR suspension, it was begin date 1/3/2025, lift date 4/2/2025.
It's not possible because it was dismissed with prejudice.
ALR suspension, appeal 12/6/2024, end
Herrera,
date 6/3/2025, and the lift date comes in at.
The two sides get deeper into dates, dismissal orders, and technical license details. The judge keeps repeating that he can only rely on what the official system, DPS, shows. The defense insists that DPS must be wrong. It's a classic courtroom clash. Logic versus bureaucracy. Facts versus system records.
And then if that,
I'm not saying you're wrong, what I'm saying is, based on what I can see, is what I can see.
if there's a dismissal order, then that suspension is contrary to law and it's void.
I'm going on what DPS says. I don't have access to what you have. I don't know. All I know is please, you don't need to put your computer. All I'm saying is that regardless, Mr. Johnson, our court order is a court
I
order.
understand.
You don't just do something willy-nilly because you think that you're in the right because of this. No, we have court orders for a reason. If you ever do this again, I will have a contempt hearing. I'm warning you now. And the next time you do something contrary to anything, I'm going to throw you in jail so fast your heads will be spinning.
The judge shifts the focus back to the core issue. Regardless of the paperwork, a court order was violated. He warns the defendant directly and sharply. If you do this again, I will put you in jail so fast your head will spin like a wheel. This is the judge's strongest emotional moment. Frustration, authority, and anger all packed into one. Do you think the judge's reaction was justified or too harsh?
As fast as a wheel. Now, you have a CDL, am I right?
Class A license, Judge.
I'm not going to put you in jail now, but I want to make sure that you're not drinking. So does he have a scram on right now?
Yes, Judge.
Okay, everything's operational?
Yes, Judge.
Don't do it again.
But there's a surprising twist. The judge decides not to jail the defendant, only because the license was technically valid on the dates in question. This small detail literally keeps the defendant out of custody. He is sternly warned, reminded of his interlock device, and ordered to stay compliant. It's a tense but relieving moment for the defendant.
The only reason I'm not taking you into custody now is because your license was valid on the 2nd and 3rd. Otherwise, you would be staying with me. Don't violate a court order. We tell you what to do, not pretrial, not anyone else. Do you understand?
Sir.
All right. Good luck, sir.
Thank you, Judge.
Good luck with your.
The judge confirms the final terms. Yes, the defendant can drive, but only with an interlock, a valid license, and insurance. The case winds down with the judge emphasizing one last time, the court tells you what to do, not pretrial, not anyone else. This ending makes the power structure crystal clear. If you were the defendant, would you trust what pretrial said, or would you go back to the judge for clarity? In this hearing, the central conflict revolved around whether the defendant knowingly violated a court order not to drive. The defense argued that the original restriction was based on incorrect information about a license suspension, while the judge emphasized that regardless of the misunderstanding, a court order must be followed without exceptions. After reviewing the timelines and confirming the license was valid, the judge chose not to jail the defendant, but delivered a serious warning about future violations. The final outcome allowed the defendant to continue driving with strict conditions, reinforcing the importance of compliance and courtroom authority. If you enjoyed this breakdown, make sure to like the video, Drop a comment. Was the judge right or was the defendant misunderstood? And don't forget to subscribe for more real courtroom moments and dramatic legal commentary.